Hey guys, so I'll be discussing Title 1, our crimes against national security and law of the nation. So it includes Articles 114 to Article 123. So let's begin. So Article 114 is treason. So treason is committed by a Filipino citizen or an alien residing in the Philippines who levies war against the Philippine government or adheres to her enemies by giving them aid or comfort. So what are the elements of Article 114? So we have that the offender is by birth a Filipino citizen or an alien residing in the Philippines, even if temporary allegiance. So the offender may either be a Filipino citizen or because he owes permanent allegiance to the Philippine government, or another offender is a foreigner or an alien temporarily residing in the Philippines. So they're called they have this qualified temporary allegiance. So during his temporary stay in the Philippines, he is given protection by the Philippine government under its laws. Therefore, it is incumbent upon him to have temporary allegiance to the Philippine government. That is why even an alien, a foreigner temporarily residing in the Philippines, can also commit treason in times of war. So, sabi nga nila, yung mga aliens daw na to, how do we say that an alien is already a resident alien? So, actually it says na we can base it from the payment of income tax, wherein paying income tax for a period of 2 years makes one a resident alien. So if it's less than 2 years, it's a non-resident alien. Kasi the RPC is actually silent about how we consider one a resident alien. So the other element number 2 is that there is a war. So the second element is that there is a war in which the Philippines is involved. So there was a case, in case of Laura, treason is a wartime offense. It says there. It can be committed only in times of war. In times of peace, treason remains to be a dormant crime. So the moment when an emergency rises, the moment a war arises, it is immediately put into effect as an act of self-defense and self-preservation of the Philippine government. So treason cannot be committed in times of peace because in times of peace, there are no traitors. So the third element is that the offender either levies war against the Philippine government or adheres to the enemies, giving them aid and comfort. So, ano ba yung treason? Treason is a breach of allegiance to the government committed by a person who owes allegiance to it. Kagaya ng sinabi natin, Filipino man siya or alien man siya. And yung Filipino citizen, again, absolute and permanent allegiance, while the resident, qualified and temporary allegiance. So, it can only be committed in times of war, sinabi na nga. Paano yung domestic war? Sabihin natin, like yung sa mga NBA. So that's not considered as treason. So paano ba nag-give rise to a war? So the Congress, by a vote of 2/3 of both houses, shall have the sole power to declare war. They're voting separately, ha? And there are two ways of committing treason, sinabi din sa third element. So it's levying war. So there must be an actual assembly of men for the purpose of executing a treasonable design by force. So what is treasonable design by force? So treasonable design by force is to overthrow and destroy the established government. And another is adhering to the enemy. So adherence to the enemy, giving them aid and comfort, is yung magsusupport ka sa kanila na mapapalago nila yung plan nila to overthrow the government and not just merely allowing them or concurring. It's actually concurring to their plan and giving them aid and comfort. And it's not just supporting them na sinusupport mo yung ideas nila. So yung dalawang to, it must concur, sabi. And it must be after the declaration of war by the Congress. Paano naman yung mga common crimes such as, for example, si A, may napatay siya kasi part siya ng mga traitors in order to fulfill their plan for that common design. So, yung crimes like murder, robbery, they're all absorbed in the crime of treason if it is for the furtherance of treason. So, treason can be committed even outside of the Philippines. So, paano natin i-prove yung treason? So, there are two ways now. The first is the two-witness rule, and the second is a confession by the accused himself in open court. And we have to note that treason cannot be proved by circumstantial evidence or even by extrajudicial confession of the accused. Kailangan in open court. So, ano ba yung mga defense naman sa treason? Sabihin natin, or hindi, let's go back first. Ano yung two-witness rule? So, kailangan dalawa yung witness na makakita na this person is committing treason. So, for example, isa lang yung nakakita sa'yo na you're doing something that a traitor would do. Hindi pwedeng mag-prosper yung kaso sa'yo. Kailangan two-witness rule. Two witnesses. So anyway, treason cannot be proved by circumstantial evidence, like I said. And defenses naman dito, ano naman yung mga defense of treason? So one is duress or uncontrollable fear. So we learned this in our Crim 1 na yung mga case na yung life nila is on the line if they don't do yung mga acts na inuutos sa kanila. And another is lawful obedience to a de facto government. So pag na-prove daw to sa court, that person may be absolved of treason. Paano naman yung defense na sabihin nila? Suspended naman yung allegiance and nag-change ng sovereignty. So, hindi yun ma-accept. We learned also in our Consti 1 that only rights are suspended in these times of war na kumari may ibang established na government and not the sovereignty itself. So we go now to Article 115, or conspiracy and proposal to commit treason. So what are the elements of conspiracy to commit treason? So sa conspiracy muna tayo to commit treason. There is, in time of war, there are two or more persons. Such persons come to an agreement to levy war against the government or to adhere to the enemies and give them aid and comfort. And they decide to commit the agreement. And what are the elements of proposal to commit treason? So it's also in time of war, of course. And the person who has decided to levy war against the government or adhere to the enemies and give them aid and comfort proposes its execution to some other person or persons. So ang general rule daw sa 115 is that conspiracy and proposal to commit a felony is not punishable, sabi nga sa Article 8, di ba? So yung exception nito is yung Article 115. So mere conspiracy and proposal to commit treason is punishable. This is because in treason, the very existence of the state is endangered. So dito, hindi nag-a-apply yung two-witness rule. Hindi nag-a-apply siya sa conspiracy and proposal to commit treason because this is a separate and distinct offense from that of treason. We go now to Article 116, so misprision of treason. So ano yung elements ng misprision of treason? First is that the offender owes allegiance to the government and it's not, so hindi to pwede makommit ng foreigner. Second is that he has knowledge of any conspiracy to commit treason. And third is that the offender conceals or does not disclose to the governor or fiscal of the province or mayor of the fiscal of the city in which the offender resides. So note that it can only be committed by a Filipino citizen and during a war in which the Philippines is involved. The offender is punished as an accessory to treason, pero principal siya in the crime of misprision of treason. So there are persons who conspire to commit treason and the offender knew this and failed to make the necessary report to the government within the earliest possible time. Article 116 does not apply when treason has already been committed by someone and the accused does not report the commission to the authorities. So to report within a reasonable time depends upon the time, the place, and the circumstance. Article 116 is an exception to the rule that mere silence does not make a person criminally liable. So we go now to espionage. So there are two ways of committing espionage. First is entering without authority a warship, port, or naval, or military establishment or reservation to obtain any information, plans, photographs, or other data of confidential nature relative to the defense of the country. So what are the elements of the first way? So we have that the offender enters a warship, a port, or etc. He has authority to do so for the purpose of obtaining any information, plans, photos, and other confidential data. So if the accused has no such intention, he is not liable. It is not necessary that the information and others is obtained. It is sufficient that the offender has the purpose to obtain them. So the offender may be a private person or a public officer, a citizen, or a foreigner. Yung second way naman is disclosing to the representative of a foreign nation the contents of the article, data, or information which offender has in his possession by reason of his public office. So the elements of the second way is that the first, the offender is a public officer. Second, he has in his possession articles, data, and other stuff enumerated therein. By reason of his public office, he discloses their contents to a representative of a foreign nation. So it is not necessary that the information is obtained. Yung intent niya is sufficient. So under paragraph 1, the offender may be any person, but under paragraph 2, the offender must be a public officer who has in his possession the information by reason of the public office he holds. So itong espionage, it can be committed both in times of war and peace. And physical entrance of the places mentioned um, has to has to be proven, and intention to obtain information must be related to the defense. It's not necessary that he actually obtains it. The offender, again, may be a citizen, a foreigner, or a public officer. So, meron pa daw ibang acts ng espionage. It was actually enumerated in Commonwealth Act 616. There are 14 more distinct acts of committing espionage. If you want to know more, you can read on this law. So we go now to Article 118, or inciting to war or giving motives for reprisal. So what are the elements? First is that the offender performs unlawful or unauthorized acts. Second is that the acts provoke or give occasion for a war involving or liable to involve the Philippines. Second is to expose Filipino citizens to reprisals on their person or property. And that, so yung crime daw na to, the intent is immaterial. It must be committed in time of peace, so hindi to war. So the penalty is higher when committed by a public officer or employee. So the intention of the offender is immaterial. The law considers the effects produced by the acts of the accused. So dalawa yung crimes na nag-give rise dito. So first is inciting to war. Second is giving motives for reprisals committed only in time of peace. So ano ba yung to provoke or give occasion to a war? So example dito is kumari, public disruption. Kumari sa Hong Kong, maraming mga domestic helpers doon. Tapos, for example, they feel oppressed or whatever. So, sinunog nila yung flag ng Hong Kong. It may give rise to a war. And public manifestation of hostility, kumari dun sa minister ng isang country or yung sa ambassador ng ibang country. So it also might incite to war. So we go now to violation of neutrality under Article 119. So neutrality, ano ba to? Is when a nation or power takes no part in a contest of arms going on between others, so referred to as neutral. There must be regulation issued by a competent authority for the enforcement of neutrality. So what are the elements of 119? So first, that there is a war which the Philippines is not involved. Second is that there is a regulation issued by a competent authority for the purpose of enforcing neutrality. And third is that the offender violates such regulation. So note that competent authority includes the President of the Philippines, the Secretary of National Defense, or the Chief of Staff of the AFP. So we move on to Article 120, or the correspondence with hostile country. So what is correspondence? It is a communication by means of letters, or it may refer to letters which pass between those who have friendly relations or business relations. So the elements are that it is time of war in which the Philippines is involved. Second, the offender makes correspondence with an enemy country or territory occupied by enemy troops. Third is that the correspondence is either prohibited by the government, carried on in ciphers or conventional signs, containing notice or information which might be useful to the enemy. So it is still punishable even if the correspondence contains innocent matters as long as correspondence has been prohibited by the government. So ano yung nagka-qualify ng circumstances dun sa law? So the following must concur. First is that the notice or information might be useful to the enemy. And second is that the offender intended to aid the enemy. So if the offender intended to aid the enemy by giving such notice or information, the crime amounts to treason. Hence, the penalty is the same as that of treason. So this article does not apply to, let's say, electronic means. So kung wari, messenger nila ginawa. Kasi specifically sinabi dito na it has to be written. So hindi naman ini-include pa. I think they still have to amend this or something. But yun na nga, yung electronic means, hindi siya mag-a-apply dito. So yung paragraph 3, it's akin to the second paragraph of treason since correspondence is intended to give aid and comfort to the enemy. We go now to Article 121 or the flight to enemy's country. So the elements is that there is a war in which the Philippines is involved. The offender owes allegiance to the Philippine government. Third is that the offender attempts to flee or go to the enemy country. Fourth is that going to the enemy country is prohibited by competent authority. So note that an alien resident may be guilty of flight to enemy country. The law does not say that not being a foreigner. So hence, the allegiance contemplated in this article is either natural or temporary allegiance. Pero paano kung yung babalikan niya na, yung pupuntahan niya na country, yung enemy country man natin, is yung country naman niya talaga. So hindi siya pwedeng maging liable for flight to enemy country if he's going back to his country where he actually owes permanent allegiance to. So we go now to section 3 or piracy and mutiny on the high seas in Philippine waters. So Article 122, Article 122 is piracy and mutiny. And here in the screen, we have two ways of committing piracy. First is we explain what piracy is. So it's any person who shall attack or seize a vessel or not, being a member of its complement, nor a passenger, shall seize the whole or part of the cargo of the said vessel, its equipment, or personal belongings of its complement passenger. This was also amended by Section 3 of RA 7659. So now piracy is committed in high seas and also in Philippine waters. So Article 122. Piracy is the robbery or forcible depredation on the high seas without lawful authority and done with the animo furandi and in the spirit and intention of the universal hostility. Di ba? Parang nasabi rin sa Crim 1, yung piracy nga, pwede siyang ikaso sa buong mundo kasi it's against all. So, yung mutiny naman is the unlawful resistance to a superior officer or raising of commotions and disturbances on board a ship against its authority of its commander. So intent to gain is essential in the crime of piracy, while the offenders in mutiny may only intend to ignore the ship officers, or they may be prompted by a desire to commit plunder. So we go now to the screen. So yung two ways of committing piracy. First is by attacking or seizing a vessel on the high seas or in the Philippine waters. This is provided for in PD 532, which I'll be explaining more later. And the second is by seizing the whole or part of the cargo of the said vehicles, its equipment or personal belongings of its complement or passengers. So we go now to the elements of Article 122. So the elements is that first is the vessel is on high seas or in Philippine water. So note that high seas may mean within the territory of another country. So sa piracy, the offenders are non-members of its complement or non-passengers of the vessel. Sa mutiny naman, offenders are members of the crew or passengers, and offenders either attack or seize the vessel, seize the whole or part of the cargo of the said vessel, its equipment or personal belongings of its complement or passengers. So ito na nga, ano ba yung PD 532? So sa PD 532, it said that piracy is any attack upon or seizing of any vessel or taking away of the whole or part thereof of its cargo, equipment, or the personal belongings of its complement or passengers, irrespective of their value thereof, by means of violence against or intimidations of persons or force upon things. So it is committed by any person, including a passenger or a member of a complement of the said vessel in the Philippine waters. So it shall be considered as piracy. So we go now to qualified piracy in Article 123. It's actually committing Article 122, but with the following circumstances. So if the vessel is on high seas or Philippine waters, the offenders may or may not be members of its complement or passengers of the vessels, and the offenders either attack or seize the vessel, or seize the whole or part of its cargo, its equipment, or personal belongings of its crews or passengers, and the proceeding was not committed under any of the following circumstances. So whenever they have seized a vessel by boarding or firing upon the same, whenever the pirates have abandoned their victims without means of saving themselves, or whenever the crime is accompanied by murder, homicide, physical injuries, or rape. So acts qualifying piracy is boarding or firing upon the vessel, abandonment of the victims without means of saving themselves, or the crime is accompanied, sabi nga, by murder, homicide, physical injuries, or rape, regardless of the number of victims. So murder, rape, homicide, and physical injuries are mere circumstances qualifying piracy and cannot be punished as separate crimes. Nor can they be complex with piracy. So any person who aids and protects pirates or abets their commission of piracy shall be considered an accomplice. So giving information about the movement of the police, acquires or receives property taken by such pirates, or in any other manner derives benefit therefrom. So ano yung difference ng piracy in the revised penal code and piracy in PD 532? We go first sa RPC. So yung sa RPC, the offender can be any person if the overt act is an attack or seizure of a vessel. The offender must not be a member of the complement, crew, or passenger if the overt act is not to attack this or seize the vessel but only to seize in the vessel the whole or part of its cargo, equipment, or personal belongings. So a person outside of the vessel kailangan daw. If galing daw sa loob yung tao, it may be robbery or theft. So the situs of piracy in high seas or in Philippine waters. And the crime becomes qualified piracy under Article 123. But there's no longer a difference in Article 122 and 123 since yung death penalty na-abolish na. So abettors in piracy are punished either as accomplices or accessories. While in PD 532, there is no distinction whether the overt act is an attack or seizure of a vessel or only to seize in the vessel whole or parts of its cargo, equipment, or belonging. The offender can be any person, pwedeng galing din sa loob. So the situs is in Philippine waters only. Di ba kanina, in high seas and Philippine waters, dito daw sa PD 532, sa Philippine waters only. So the circumstances that make for qualified piracy in Article 123 are also the same circumstances in Section 3A of PD 532. And the penalty for simple piracy in PD 532 is reclusion temporal and qualified reclusion perpetua. So there's no distinction whether you cooperate in the execution of the offense by previous or simultaneous acts. You are punished as an accomplice. Kanina, di ba, accomplice and accessories. So any of the crimes referred to in Article 122 includes mutiny. So mutiny can be qualified, but the first circumstance in Article 123 can only apply to piracy. So dito sa mga to, the same penalty shall be inflicted in case of mutiny on the high seas or in Philippine waters. So all in all, in this title, all the offenses under this title can only be committed by public officers, kung napansin nyo. Except, first, offending the religious feelings under Article 133, that's in another video, or when he conspires with the public officer, or when he becomes an accomplice or accessory to the said crimes. So this was Title 1 of the Revised Penal Code Book 2. So from this is like the first half. I first uploaded the second half of the videos. If I made any mistakes, please bear with it. And I hope this helped your review in criminal law too. Thank you for listening. Stay tuned.